My name is Sam Nolan of Richards, Layton and Finger, and I'm speaking today with Gil Sparks of Morris Nichols Harston Tunnel about the Unocal case that was decided in 1985. Gil, your firm and mine were on opposite sides of that case, so this interview feels a little bit like those old reunions of Civil War soldiers that you see reaching across, shaking hands in reconciliation over the wall that marked Pickett's charge at Gettysburg. One side was victorious and one side wasn't. And I don't mean to imply that you go all the way back to the Civil War. You were
Oh, thanks.
you were a dynamic young partner in the 1980s and beyond, of course, but certainly in the 1980s. Before we turn to the Unocal case itself, can you tell us a little bit about the early 1980s and how takeover law developed and what your role in it was?
Yeah, I sort of marked the beginning of the takeover period actually just a little bit earlier, around 1977, 1978, when I started as an associate at Morris Nichols, which was in 1973. The main takeover device remained the proxy contest. And even they were relatively rare. But in 1977, the U.S. Supreme Court decided the Green versus Santa Fe case, and that made it clear that fiduciary duty matters, including the role of directors in Delaware corporations, was a matter that was going to be decided in state court rather than under the federal securities laws in federal courts. And right about that time, the more modern tender offer technique began to develop. And the first major case I remember doing with Wachtell Lipton was Carrier United Technologies, and that was in 1978. And from that time on, there was just an ever-increasing amount of this tender offer activity, which our case law and certainly our statutory law had not really contemplated, and so you were writing pretty much on a clean slate in terms of what the duties and responsibilities of directors were and were not during that period. And we ended up, if you now, with the benefit of hindsight, look back, and you could say that that law really developed from about 1980. 1981, when we started to litigate things like the Van Gorkum case, up through about 1993 or 94, when you had some of the final touches put on the common law. And mixed in during that period was also activity legislatively in the area of director protection, and a couple of generations of state takeover statutes, including two in Delaware, first generation statute and what you could call a second or perhaps third generation statute.
The law, as I recall it, in 1980, in the early 1980s, was very unclear even on whether the board could take an active role or only a passive role in takeover defense.
Right. And that began to clear up even a little bit before Unocal. There was a Panther Marshall Field case decided in the federal courts that seemed to put the directors in a role of not being passive, but actually having a role in defending their stockholders against predatory activity. And then in the Delaware Supreme Court, there was a case called Pogostin that sort of echoed the same thing as Panther versus Marshall Field. In fact, I think he even cited it. And was the first hint that the Delaware courts were going to say, all right, part of the director's job is to defend stockholders. Or another way of looking at it more technically is that under our statute, Section 141A, which deals with directors having the right to manage the business and affairs of the corporation, that the business and affairs of the corporation included not just the corporation internally, but also embraced a role with the stockholders. In other words, the stockholders' well-being was part of the, quote, business and affairs under that statute, which is the hook that the court used to get into this area.
So the the protection of shareholder value, for example.
Yes, and as we moved on toward some of the activities that gave rise to cases like Unocal, it became clear that there were techniques that acquirers could use, which in effect would set one group of shareholders against another, or would cause shareholders to have to take actions which might not be economically beneficial in the abstract because they were afraid of what their fellow stockholders would do. And in the case of a front-end loaded two-tier tender offer, which is one of the techniques and certainly the one that was dealt with in the case that we're about to talk about, that was the problem, that whether you really wanted to tender or not, you didn't have a real choice, because if your fellow shareholder tendered and the acquirer, I'll use the term acquirer rather than rater, that the acquirer got 51%, and you had said, well, I really don't want to sell, so I'll hold on. You were the one who was going to get stuck with the risk of whatever was going to be on the back end, and you couldn't afford to do that, so you had to tender even if you didn't really want to.
Right, and other defensive mechanisms were beginning to come into play too, like advance notice bylaws.
We had advance notice bylaws. We were beginning to have some of the statutory activity, like other constituency statutes. The poison pill was around by 19. Right, it was around because it was litigated right after Unocal, and its validity was affirmed in a relatively short period of time after Unocal. Indeed, the two cases have interesting overlaps, since the household case began before the Unocal case, and the Unocal case started and ended before the hearing in the Supreme Court on the Moran household case, all of which created an interesting dynamic both for me and even more so for your partner, Charlie Richards, who was on one side of the issue, if you will, in one case, and the other side of the issue in the other case.
And I think Charlie has reminded us that household was argued on the Tuesday following the Friday ruling of the Supreme Court in Unocal.
Right, and I have never made a practice of going to arguments in matters that I didn't have a client, but in this particular instance, the Moran case was so interesting, and that I sat in the audience, and at one point in Charlie's argument, the court pointed at me, said, "Now, last week, Mr. Sparks made this argument. What do you say to that?" And I doubt that's ever happened before, but it just shows how you could step back now and look at these cases and think of them individually. But this was all part of a matrix, as the practicing bar and more importantly, the Chancery Court, and most importantly, the Supreme Court, sought to develop a rational construct of common law that would govern in this area where there had really been no law at all before.
And the bar that worked on these matters was very small, as I recall.
Yeah, they were probably certainly less than 10 of people who were on the front line. There was, of course, your partner, Charlie Richards. There was Frank Bellotti. There was Rod Ward. There was me. And there were a few people on the plaintiff's bar. And I guess Bruce Stargett dipped his hand into this every now and then. Mike Goldman. And that's about it. I mean, there may have been, I'm sure I've left out a couple, Bob Payson, left out a handful, but there weren't many. And indeed, one of the reasons why this happened, at least in my case, was when all this started to break, I had either almost become a partner or had just become a partner. And of course, I had a little less hair and I was a little older because I had had some military service, so people thought I was older than I was. But my senior partners, who had a career where they were able to sit down and sit around a table and talk about the strategy and then take a lot of depositions and head toward a big trial, they didn't really have much interest in the lifestyle that was associated with trying these cases, where you would come into the office on a Monday thinking you were flying one place, and by the afternoon you were flying someplace else, and you were pursuing schedules that are similar to the ones we'll talk about here in Unocal. It was a younger person's game, at the time. Charlie Richards was a little bit of an exception. He grabbed hold of this, but people like Frank Bellotti, myself, some of the others, you move forward faster than you otherwise would have. You could say it was being in the right place at the right time, or depending on what you think about lifestyle, you could say it was being in the wrong place at the wrong time. But it certainly turned out to be the right thing for my career, and having lived through it and still being around, I look back fondly upon these days. But I look at these schedules and ask myself, how did we ever do it? And we didn't have, and the firms weren't nearly as large back then as they are now. I mean, I did it with the help of, and all these things were done with a team. I mean, you can be the lead person and take credit, but you really shouldn't. It's really a close-knit team. And in my case, I had Professor Hammermesh on my team, who was frankly my most senior guy, and some young people like Ken Nakbar, all of them, willing to put in the hours alongside of me. And but you lived through the same thing, so you know exactly what it was like.
I do know exactly what it was like, and I was a bit younger than you, younger even than Professor Hammermesh, but still, I think you were in your early or mid 40s. When this was going, Charlie, I remember, was 48 at about this time.
Yeah, so I was born in 1944. So when this all came about, I was 41 years old. In fact, there had been a Newsweek article just a little bit before, which was something called 40 under 40 or something like that. I remember that because the other person that I had ever heard of other than myself on that list was Hillary Clinton. So I guess you could put me in sort of the same generation as Secretary of State Clinton.
Yeah. Well, the court makeup also made a major change around in those early years of the 1980s. New people came on the Court of Chancery. Bill Allen, right. Carolyn Berger, both of whom were very, very dynamic, intellectual, hardworking, knowledgeable.
Right. I mean,
people.
if you think about the generational change, probably looking at the chancellor position is the easiest one. We had a very old school, solid judge, but very old school, and in Chancellor Marvel, and he leaves, and we had Chancellor Allen, and it's sort of night and day in terms of sort of intellectual dynamism, and it's a different style. Not to say that both of them weren't really good judges, but it was different. And in the Supreme Court, this was the period of time when it was a little bit different in terms of looking at the Supreme Court. Justice Moore, who was younger and had and interested, intensely interested in this dynamic of how this was going to play out, really was the dominant figure. And if you go and read the arguments in this case, or you look at the arguments in some of the other cases, Revlon, having looked back at fairly recently, I mean, 90% of the questions, 95% of the questions are Justice Moore's questions. I mean, he was the intellectual leader of the court during this period.
And so the courts changed the nature of litigation, the speed of the litigation, I think, also really changed and developed in this time.
Yeah, so a couple of things happened. When this all started, these tender offers, it was extraordinarily fast because the Williams Act, which was the federal act governing tender offers, basically permitted a tender offer to open and close in 10 days. Somewhere in this period, in the early 80s, that got a little bit better because that got extended to 20 days. But 20 days isn't very much when you think about all that happens in one of these cases, where you're saying, well, somebody makes a tender offer, somebody has to respond, somebody files a suit, and then you go through 2 layers of courts, briefing and argument and discovery, and it's all got to be finished less than 3 weeks before it started, which is why I said at the beginning that there were certainly instances where you would come in on a Monday thinking you were going off to take a deposition in one city on a case that was a regular case, or perhaps another accelerated case, and by the time the day was out, you were winging off to someplace else to deal with one of these super fast experiences.
And you had, by the time of the Unocal case in 1985, you had gone through quite a number of these cases, as I recall, including cases involving Mesa Petroleum and Boone Pickens before.
We had. I don't know if I had been the lead in any of the Pickens cases, but I've been through and been the lead in things like Van Gorkum and a number of other takeovers that were less famous than this one. But I do distinctly remember being a lead Delaware counsel in the Gulf Mesa episode, and I can't remember if it was before or after this, but it was probably before that I had a role both as a litigator and on the corporate side dealing with Mr. Pickens' attempts to take over Phillips Petroleum.
Yeah,
Those are the two that stand out to me.
Phillips was just before this one, I think it ended.
And that one had a number of chapters to it. It was Mr. Pickens, and then somewhere Edelman got involved, and Icahn got involved, and I have some very distinct memories of being at Bartlesville for a lot of that activity.
Well, why don't we turn to the Unocal case itself,
Right.
with that background. How do you remember that case coming to you? How did it develop?
Well, we had a relationship with Gibson Dunn and Andy Bogan in particular, and I can't remember specifically if that's how we got involved, but I strongly suspect it is. Andy had a relationship, a professional relationship, both with me and with my partner Lou Black, and Lou and I were sort of the corporate guys, and then I was also the litigating guy at Morris Nichols. This all started off with a lawsuit, which now has faded into the mist, having to do with an advance nomination bylaw, and we were called upon to defend that. We basically lost that. It was an interpretation, but it was another piece of accelerated litigation. It was an interpretation of whether a 30-day notice period was measured from the date of the original notice of a meeting or from the time that you adjourned the meeting and set a different date. That's generally what I recall. And we had taken the more aggressive position that it was from the earlier date, and that was ultimately TRO'd against us. And then by the time that, I don't think that one ever went much further because these other events overtook it. In terms of the defensive tender offer, and again, I know I was playing sort of a dual role as some of us did in those days. Where the firms were smaller. I know your partner Frank Bellotti sort of did some of the same thing. I can't remember which board meetings, for example, particular board meetings I attended at Unocal's headquarters in Los Angeles, but I know I have a distinct recollection of attending one before this tender offer activity began. I can remember who was there. I can remember the setup of the beverages against one wall. I just can't remember exactly which meeting it was in terms of the substance of it, but we were sort of fulfilling both roles.
Well, that's an important point that we probably shouldn't gloss over. And before we go on with Unocal, is the role of the Delaware lawyer as being not just a pure litigator
Right.
on these issues, even specialized in takeover issues, but also as an advisor on the transactional side.
Yeah, and in my particular case, I began as basically a pure corporate lawyer, mentored by Sam Arsht. And after 3 or 4 years of that, I actually went to Sam and I said, look, I would like to also be involved in litigating some of these matters because I think the opinion-giving side of the business would be better if I had actually lived through having to see how the courts view these things and be involved in defending some of the stuff that we advise about. And that was right about 1977 that I remember having that conversation. So he said, sure. And then very sort of the advice-giving side of it was still there, but the litigation exploded in the time period we're talking about. And it really did help to have had that background, because Sam was a wonderful teacher, just like some of your partners in the corporate area were wonderful teachers. And I entered this litigation area knowing the Delaware corporation law backwards and forwards, which just was really helpful, especially when I was up against dynamic people like Frank Bellotti, who also knew the Delaware corporation law backwards and forwards. And it was always good to be able to checkmate him once in a while.
Well, it also, I suspect, you tell me, gave you more credibility with the court, because the court understood that you knew what transpired in boardrooms, and by the same token, directors knew that you understood what happened in courtrooms.
Right, it did. I mean, I don't think there's any question about that, and it was one of the things I treasured up until the time that I left. Was I think I left the active practice with my credibility with the Delaware courts still intact, which was a good thing.
Yeah. Well, I think that's for certain, and I think we've lost a little bit of that cross-fertilization over the years,
well,
but it's necessity.
It's inevitable. The firms are bigger. The division of practice has become a little bit more like it was in New York with the bigger firms, where you have the corporate guys and the litigating guys. I just hope that at least they still talk to each other.
Well, back to the Unocal case itself, the little brush fire about the advance notice bylaw, I think, started the litigation
Right.
on something like April 12th, if I recall correctly, and was decided within about 10 days.
Yep.
But the case quickly morphed into something quite substantially different, and that involved a discriminatory self-tender. Can you tell us how that came about? How did that develop, that idea?
Well, I know I was involved in discussing it. I could not tell you precisely whose idea it was. My guess is it was a investment banker originated thought that they said, well, could we do this? And I mean, people were thinking about all sorts of things, but somehow between the lawyers, which the lead guys would have been Andy Bogan, Lou Black, and then Lou would say to me, was this going to fly? What's going to happen? and so it just became a thing to try. And obviously there weren't a lot of other things to try, or because this was untried, as the record pretty clearly shows. I think the contemporaneous record even shows that the board knew that it was it might work and it might not work, but it was the most intelligent thing to do under the circumstances, and it had the advantage of saying, all right, if we're going to lose this thing, at least our stockholders are going to get a chance to get this higher priced debt in substitution for what they may get left with in the back end, and so it was not just a defense, but it was also an effort to try to put value into the hands of shareholders in the event that we were unsuccessful in fending off Mr. Pickens, because it was always possible. It wouldn't have necessarily been a showstopper. I mean, he could have lowered his price, and maybe it would have been a bit successful at a lower price or not. You didn't know. But as it turned out, when it was all over, he left the field, and the defense was completely successful.
So the nature of the defense was to announce a tender offer that all stockholders other than the acquirer, than Mesa,
and the acquirer's transferees, so he couldn't escape by selling to somebody else who could then take advantage of the tender offer. But
Right.
yes, this offer would be made to everyone, and it was at a generous price and valued at it was of note, but it was valued at 72 or 73 when his offer was 54.
And so it's a little bit of a jujitsu move, because what you're doing is you're doing a two-tier tender offer, but the second tier, the risky tier, is being imposed on the offeror.
You could say that. What it really was leveraging up the company and in effect saying, all right, it's the equivalent of paying a special dividend to everyone except not the person who's causing you to have to do it in the first place.
Was there any case law on this defense before?
Not
before
really. I mean,
you
the
did
only
it?
thing that was out there, and both of us found it, was this very thin, I'd say thin in the sense it was about 4 pages long, an unreported case called Fisher versus Maltz, which ended up being what Vice Chancellor Berger hung her hat on, because that was all that was out there. I think it was a Hartnett decision. But it had elements of similarity to this, but not really. It was a case in which there had been a buyback tender offer to all stockholders except one. That part was similar. But the one wasn't trying to take over the company. He wasn't making a tender offer. It was somebody that they hated because he had been an employee and now was competing against the company, apparently lawfully. And so as the case went on, people were characterizing it as, well, they didn't have a valid corporate purpose for doing it. They just hated him. And so it had the similarity of being an instance in which somebody had been excluded, and in this case, it was found to be unlawful because in that they didn't have a, quote, valid corporate purpose. Back at the time when, under Tanzer and other cases, valid corporate purpose was still a part of our law. It subsequently, by the time of Unocal, had been overruled and wasn't part of our law anymore. But that was really the only thing that was the only case law that of any substance, and it wasn't very substantive, that we found. It was adverse to us. It was Charlie was able to ride it through the Court of Chancery, but by the time we got to the Supreme Court, it wasn't getting much attention from the Supreme Court. It was still there to be talked about, but it was not the biggest issue as we got down to the brass tacks and the pure legal question at the end. On our side, we had the interesting argument that Sheff versus Mathis and Cords versus Carey were cases where corporate directors had been permitted to pay greenmail to buy out someone who was a danger to corporate policy and effectiveness. And the interesting twist there was that, well, of course, that person had taken the money. All the rest of the stockholders, who were the ones who were suing because they didn't like the fact that money from the corporate treasury had been spent to buy this person out, they were the ones who were being discriminated against in the jargon of what we were talking about. And we had a series of just interesting discussions about that with the Supreme Court and even I think in the Chancery Court, where people would be saying, well, the greenmail buybacks are okay because the person who got the money consented to it. That was an argument that Charlie was, I think, making to sort of say that's the distinction. And we would say, yeah, but the people who were suing didn't consent to it, so that really doesn't fly. That doesn't get you anywhere. And so we were hanging our hat on to the extent there were any cases, and you could see how remote even those cases are. They're really not the same case. But we were saying, look, if you're going to say this is illegal, then what about those cases? And Charlie was saying Fisher versus Maltz says this is just can't do it. It's unlawful.
So you went through a restraining order proceeding in the Court of Chancery before Vice Chancellor Berger,
Right.
and she ruled against you on that. On that.
She ruled against us, but she did us a great service because she basically left us with a pure legal question if you account for the standard of review that the Supreme Court was going to have to deal with. So she just didn't think you could do this, and she looked at Fisher and read it and said, you just can't do this. But she credited us with good faith in terms of deciding to do this, that we didn't do it to line our pockets. We did it because we thought it was in the best interest of the shareholders. And she credited us with having exercised due care in doing it. And she really didn't give much weight to any sort of loyalty issues that otherwise you guys were advocating, Charlie was advocating. So when we got to the Supreme Court, we really just had this pure legal question of is this under these circumstances with a majority of independent directors acting in good faith, acting with due care, and after considering all its options, acting for what they believed was a proper purpose to try to protect other shareholders. Nonetheless, were they legally prohibited from making an offer that excluded Mesa? That was the issue, and it was, and so it was. I mean, there were still some arguments. Charlie made at the end of the oral argument, I'm sure in the briefs, saying, well, we don't really agree with the vice chancellor on this or that, but the standard of review was such that we were in pretty good shape on that, and that's the posture we were in when we went down to argue this case.
So there were a couple of steps between the restraining order and when you went down to argue the case in the Supreme Court. One of those steps was that you applied for certification of an interlocutory appeal.
And my recollection is that I had a pre-scheduled vacation, and if you look at the schedule of these cases, you say, well, how could anybody go on a vacation in the middle of all this? But this wasn't the only case, and I throughout my career, I pretty much said to my partners, and I said, look, I'm blocking this out months in advance. If something comes up, I want somebody to step up for me because I'm going to do this, or I'm not going to have a life. Because you would never be able to leave. So I asked Dick Sutton, who was a very accomplished lawyer in our firm, and more willing than most to get into these frays in terms of my senior partners, and he very kindly agreed to handle, as I recall it, the interlocutory appeal effort after the TRO to the Supreme Court. And while we didn't get the interlocutory appeal at that stage, what the Supreme Court did was say, well, we have some time here, enough time to allow the Vice Chancellor to hear argument and issue an opinion. And I think that we already had an argument scheduled on the preliminary injunction for like May 8th. And so the court says, okay, we're going to wait a week and let her hear this and give us an opinion. Then we'll have more to work with. Which turned out to be a great blessing for us, very frankly, because she then cleared away all these other issues that were in the case. And we want the court to focus on 4 questions. And those 4 questions, which I assume you have in front of you, but I have in front of us, important enough that I sort of made an effort to pull them out. And those 4 questions were, does the director's duty of care to the corporation extend to protecting the corporate enterprise in good faith from perceived depredations of others, including persons who may own stock in the company? That question didn't sound too bad to us. And then the next one was, have one or more of the plaintiffs, their affiliates or persons acting in concert with them, either in dealing with Unocal or others, demonstrated a pattern of conduct sufficient to justify a reasonable inference by defendants that a principal objective of plaintiffs is to achieve selective treatment for themselves by the repurchase of their Unocal shares at a substantial premium? That didn't sound so bad either, given Mr. Pickens' history. And then third, if so, may the directors of Unocal, in the proper exercise of business judgment, employ the exchange offer to protect the corporation and its shareholders from such tactics. Citing Pogostin versus Rice, which is the case that had recently been decided by the Supreme Court like a year before, that said the board has a role in all of this. And then D, if it is determined that the purpose of the exchange offer was not illegal as a matter of law, have the directors of Unocal carried their burden of showing that they acted in good faith, citing in Martin versus American Potash. So those were the directions that the court was giving to Vice Chancellor Berger. She answered all of those questions. She answered 3 of them in the affirmative. The only one she answered in the negative was, could we use this exchange offer to counter such tactics? But that was a pure legal question after you had found that we had carried our burden of good faith, that we that she had sort of found that while she couldn't, there was no proof. She said there was a reasonable inference that Mr. Pickens was in this for himself, i.e., trying to in it for himself, and then and she found the duty of care had been satisfied. So that was actually a positive development. And of course, in this order, the Supreme Court also made it clear that once this Chancery Court opinion came down, they were going to take the case. It was just a delay in taking the case. So that was an encouraging thing. And then, of course, the next step was the Vice Chancellor's opinion, and that was encouraging to the extent that I mean, we lost, so that wasn't great, but it was encouraging in terms of the way she dealt with these questions and gave us the best shot that we could have possibly had going into the Supreme Court argument.
Right, and then, and that opinion was then on an expanded factual record because it was a preliminary injunction opinion.
Correct. So it wasn't the pure trial standard of review, but there was a written record, and it was pretty clear from the court's discussion that it was going to give it something close to that Levitt versus Bouvier deference. She having found all those things, having had an opportunity to review the extensive or relatively extensive written record. I think there was some. I mean, it wasn't a great written record. There weren't that many depositions, but there were enough to allow you to figure out what was going on.
There were some affidavits,
and there were
as
affidavits,
I recall, and
right,
I think there were some depositions, but really the factual record was put together in about 10 days.
Right. And there wasn't a
from
lot
soup
of
to nuts.
dispute about the factual record. I mean, there was some sniping by you guys at whether there had been too much of delegation in terms of some covenants that were in the notes and some other stuff. But it was pretty clear what the issue the court wanted to address.
And I think about the scope of the investment bankers' presentations to the board too. Had they really made valuation presentations, or had they just talked about their methodology and then
there was some stuff about, well, too many directors were on the phone and the slides didn't get into the depth, but that was none of that. That was sort of the stuff at the end of the oral argument when Charlie sensed the way the wind was blowing, I think.
I think certainly on our side, but I suspect on your side too, that you could read these 4 questions and the other aspects of Justice Moore's order as really giving a roadmap for how the Supreme Court was likely to come out on this.
Well, I can't remember being that confident because I can remember really not knowing how this was going to come out the day we went in to see the oral argument. I know exactly when I knew when it was we were going to win, but it wasn't until we were in there and Justice Moore had begun speaking that I knew we were going to win. Because this was novel. I mean, this was important. It was different. It was new law. And you could never be sure, but certainly we had some reason for hope, I think, as we went down to the finish line.
Well, as I recall, the Chancery opinion came out on the 14th of May or thereabouts. You filed, I think, your supplemental notice of appeal that day, and your opening brief.
Right, I think that's right.
On appeal that day.
I mean, it was all done very, very quickly.
And the answering brief was filed the following day.
And the reply briefs, I think, were filed on the day of the argument. So there was, as often happened in these matters, on one hand, I would have been sitting there trying to fashion my argument to the Supreme Court. in whatever style I used, and on the other hand, I'd be looking at drafts of briefs and they'd be coming across my desk and hoping that I, caught all the typos, or that we didn't send a brief that had a blank page in it or anything like that. But yeah, it was a hectic period, and for both sides.
Now, tell me about the argument itself in the Supreme Court.
Well, there were a couple of interesting things. For the most part, I thought Justice Moore, who was the only questioner, maybe Judge Taylor asked a question or something, but basically Justice Moore was asking all the questions. And they weren't quite softballs, but they weren't hardballs either that I was getting. The most interesting discussion was with the concept that had come up in a case court below, where he was trying to sort of probe what I was talking about, which ended up being, I think, part of the reasonable in relation to the threat posed test, where I had talked about the question had come up in the Chancery Court: what fiduciary duties are owed to Mesa in this context? And I had sort of characterized at one point in that answer, which probably wasn't the best of my answers, characterized it as sort of a springing fiduciary duty, and then I had gone on to make it clear that we got the duty of care, we've got the duty not to do anything illegal, we've got the duty to be reasonable, rational under the business judgment rule. And this springing fiduciary duty thing, I guess, had been seized upon a little bit by Charlie and interested in Justice Moore, and we talked about that in the argument. And I think I did a better job in the Supreme Court in explaining how this worked. And we still got plenty of fiduciary duties owed to Mesa. We just don't have a duty to lay over and not defend our other stockholders from a depredation, if you will. And so I remember that. And then Charlie got up, and he was getting harder questions. And then sort of toward the end, Charlie started to wing it a little bit, I think. At one point, I do remember, because I can remember this, he said, well, we're being deprived of equal protection of the laws. Well, that was getting a little bit far out there. And I remember responding to that one in my very short rebuttal saying, well, Your Honor, this isn't a constitutional case. There's no state action. And I said something else about that. And then I got up at the end, and I actually looked at this, and I wrote yesterday that this was a pretty good close. I said, finally, Your Honor, I submit simply that Delaware law in this area cannot be static. I had made that point once before. I'd also, somewhere earlier in the opinion, alluded to the idea that of something that was sort of similar to what it turned out to be with a reasonable response to the threat posed, because we had the business judgment rule, and that was talking about rationality, and I think I sort of said reasonable under the circumstances, and maybe they morphed a little bit of that into the reasonable response to the threat posed. So finally I said, Delaware law cannot be static. We didn't have professional raters in 1964 when Sheff was decided, and we didn't have front-end loaded two-tier junk bond tender offers. We have them now, and I think our law has to keep up to date with that kind of reality. I think in this case it's easy because they in effect are asking for a change in the law. And we are simply asking the court, now that it has squarely put directors in the position of having a duty to stockholders to protect them from inadequate offers, to not take away the tools to allow them to do that in good faith. And that really summed up fairly succinctly, which I wasn't always that good at, but in this instance maybe I was okay. Succinctly what we were trying to say, and we then had a little bit of debate about when this thing had to be decided, and it was pretty clear that the proration date was going to be the next day, and the court said we'll take it under advisement, and then later on we got notice that the court would be pulling everybody together for an oral ruling at 9 a.m. This was the next morning.
9 a.m. the next morning. So when you left the argument, how did you feel it had gone?
I must have felt it was better. I certainly didn't feel that we had been blown out. I still know. I can still tell you my present sense impression because I know when it was that I knew we had won, and it wasn't until the next morning after Drew Moore started his remarks. So, like in all cases, there have been cases in my time that I thought I had won and I lost, and vice versa, and you never know. But I don't have. I'm sure I had no sense of, oh my God, this was awful. At a minimum, I thought we had held our own, and I certainly knew. I knew that I had gotten our points out, and that unlike a case like Revlon, where I knew I had lost after Drew Moore told me that the Supreme Court didn't mean something it had said 2 weeks before, or a month before, or a year before. In this case, I didn't have any of those feelings.
So the ruling then was the next day,
Yeah.
and this appeal had started on Monday, and now the final ruling of the court is on Friday after a full briefing and
Right.
argument and so forth, which is pretty extraordinary in the first place.
Yes.
But then the court pulled everybody, as you said, together at the early morning.
Right, we were in
next day.
in the big courtroom, which is now part of Young Conaway's offices. It was the grand jury courtroom. It probably seated a couple hundred people. And this wasn't the only time they did this, but what they did was bring everybody in, lock the doors, tell people they couldn't leave until the court said they could leave, so that people weren't running out to call their broker. There were people hired by arbitrators to come to these hearings, so they would get the first word. And the Supreme Court didn't want anybody dashing out of the door after the first few words that the court said and predicting how the case was going to come out. So they said everybody has to stay. And I was there. I think Ken Nakbar was with me, who had helped on the team on this case. And the court came in. And I can tell you exactly when it was that I knew that we had won, because at page 5 of the oral opinion, after some preliminary remarks where Justice Moore had told people, I think he told people don't leave. He said, I'll ask no one leave the courtroom until the court is recessed. And then he said, sort of patted themselves on the back as to how quickly they had acted. And then he began to talk about, the substantive portion of his ruling. And he said, Mesa commenced a tender offer for 64 million shares, or 51% of the common stock at Unocal at 54 cash per net share, and announced its intention to propose the acquisition of the remaining publicly held shares of Unocal in exchange for securities having an aggregate market value of $54 per share. Then he said, this is known as a two-tier front-end loaded tender offer followed by a back-end merger in which the remaining public shareholders of Unocal would be squeezed out by the issuance of highly subordinated securities, resulting in a capitalization of the surviving company which would differ significantly from that of Unocal as it is today. At that point, I leaned over to Ken and I said, we're going to win. Because there was no way that any court could let a monster such as this roam the legal landscape any further. A two-tier front-end loaded tender offer followed by a back-end merger in which public shareholders would be squeezed out by the issuance of highly subordinated securities. And it was delivered in a tone of voice by Justice Moore that just made it clear that this wasn't going to be tolerated as part of our Delaware legal landscape in a circumstance such as this. And of course, then he went on and announced the opinion. And the only other recollection I have of that, the next recollection I have of that day, other than some very generous congratulations by other members of the bar as I left the courtroom, was calling Sam Snyder, who was the assistant general counsel of Unocal, who had really been a functioning contact in all of this, and he was scheduled to assume the general counsel role like 2 weeks later, because the gentleman who had been general counsel was retiring, and that was all a pre-known thing. And so this is 9 o'clock in the morning, so we're getting back to the office like 10, but it's like 7 or 6:30 in the morning in Los Angeles. So I get him at his home, and I said, Sam, we won. And he says, thank God. He said, I went to bed last night, and I didn't know whether there was going to be a company for me to be general counsel of. And he was a real nice, sort of good old boy guy, a very, very nice, down-to-earth gentleman. And that made me feel very good. That I can remember feeling very good about that.
Well, the Unocal case, of course, created an entirely new standard of review, and that persists today. So you were present at the creation and a factor in the creation of it. What recognition, other than Sam Snyder telling you that he could sleep better at night, did the client give you? Sometimes clients win these things.
This one was very interesting. Somewhere in the next couple of weeks, there was some. It was like an appraisal case having to do with this. Under Pennsylvania law, it was a very small case involving 1 or 2 shareholders in some remote county in Pennsylvania. But they asked me if I would handle it or if I would supervise it. So I, of course, said yes. Nothing much was happening in this case. And then a week or 2 later, 3 weeks later, they asked me to come out to address the board on the status of this relatively insignificant case. And I said, okay. So I got on a plane and I flew to Los Angeles, went into the board meeting, and got introduced. And it turned out that the only reason they wanted me out there, I never did get to never said a thing about this case. It was simply an opportunity for them to have me come in, and the entire board got up and gave me a standing round of applause and thanked me for what I had accomplished. And that was better than any bag of peanuts or champagne sent to my house or anything like that. It was a very, very nice gesture, and so I remember that. It never happened to me before. It never happened to me after, and it probably hasn't happened to very many lawyers in this field of work. So it was a great compliment.
Well, most of us move on from these cases, especially if other pressing cases are popping up, and I'm sure you did as well. But one of the things that happened just within about 5 weeks of this decision was that the SEC announced a rulemaking initiative to outlaw discriminatory self-tenders of this type, the all holders rule.
Right.
Do you remember that?
I remember that happened, and I remember saying or thinking, well, I guess we couldn't do this one again. This is a defense that had a brilliant but very short shelf life, and that basically, as a federal matter, meant this particular device wasn't there. But if you think about it, it's not a whole lot different than what the rights plan does, which Moran decided, because in those circumstances, the person who triggers the rights is excluded from whatever it is that the rights plan gives everybody else. It's the same model. It just didn't happen in the rights plan in the context of a federally regulated tender offer. It happened in a different context. So, and it would be interesting, and it will be interesting, I'm sure at some point for these oral histories, if it hasn't happened already, there'll be some discussion with Charlie about Unocal, and then how that played into his thinking with respect to Moran. But after Unocal, one had to be encouraged about how things were going to work out in Moran because of the very fundamental fact that it basically is authorizing inappropriate circumstances under a Unocal type examination, which ended up being at the end of the game in the rights plan context, saying yes, you can discriminate if it's reasonable in relation to the threat posed.
Which was the new standard.
Which is the new standard.
That Unocal set.
Which then played on in a sort of variant, then they sort of reiterated it as a variant in Revlon, where it became reasonable in response to your obligation in certain contexts to promote a balanced auction or sale process for the company. It continues to echo even after tweaks in Unitrin and some of the other cases. It's still bedrock good Delaware law 32 years later.
Well, and it seems to grow really out of equitable concepts rather than legal concepts,
Right, but
which makes Delaware a little bit of an outlier in terms of how
we
it's
do it.
able to develop the law.
Right.
So what happened to Mesa after Unocal closed its self-tender?
Well, I've always told people that in terms, we can do it at two levels. I wasn't involved, but I understand there was some accommodation reached with Mesa. I don't know precisely what it was. Maybe Charlie does, which ended up them exiting the enterprise. So they didn't stick around as a 13% stockholder or whatever percentage they had. So it wasn't probably as financially devastating as it might have been if you had just let things play out. But they were gone, and frankly, I think it got Mr. Pickens out of this business. I don't believe I remember him surfacing in a material way. Again, I think he's had other ventures that he has successfully pursued. I see him on Squawk Box from time to time, or at least did up until the last couple of years, where he'd be talking about wind power, and of course Mesa was an actual operating company in the Texas oil business. But I think this was sort of the end of the road in terms of his pursuing the technique that he had been pursuing with Phillips, with Gulf. I can't remember. Maybe it was a couple of others in the oil patch.
And Unocal is no more.
Unocal, unless it's in some truncated form, is no longer a public company. It was merged. I'm not sure who it was. Was it Chevron? Somebody bought it. And it went through some mutations over the years, but no longer I don't believe you can any longer buy Unocal gas at a Unocal gas station on the West Coast, and no longer is the orange Unocal sign on the wall at Dodger Stadium.
Gil, this has been very interesting. I appreciate your telling us these insights and the background stories of this. I think it makes it come alive. Thank you very much.
Good luck in finishing with the other witnesses to this event, if you will, and hopefully at some point I'll get a chance to look at the final product.